Before Kyle Rittenhouse ever took the stand, the case was already fighting over a single question: what counts as intent. On August 25, 2020, amid unrest in Kenosha, a 17-year-old crossed state lines with a rifle and ended the night having shot 3 people, 2 dead, 1 wounded. Prosecutors responded with a stack of serious charges, including intentional homicide. The defense answered with one word: self-defense. But the real battleground wasn't the street. It was evidence. Just weeks before trial, prosecutors tried to introduce a short video recorded days earlier. A clip where Rittenhouse is seen commenting on suspected shoplifters and saying he wished he had his gun. To the state, it showed mindset. To the defense, it was poison, unrelated, speculative, and dangerously prejudicial. Judge Bruce Schroeder kept it out, at least for now. And that ruling mattered more than most people realized. Because once Rittenhouse took the stand on November 10th, the prosecution's cross-examination wasn't just about what happened that night. It was about whether the jury could be led to believe this shooting began long before the first shot was fired. And that's where this trial truly turned.
The person who was attacking me.
By killing them.
2 of them passed away, but I stopped the threat from attacking me.
By using deadly force.
I used deadly force.
That you knew was going to kill.
I didn't know if it was going to kill them, but I used deadly force to stop the threat that was attacking me.
You intentionally used deadly force against Joseph Rosenbaum, correct?
Yes.
You intentionally used deadly force against the man who came and tried to kick you in the face,
yes.
Correct? You intentionally used deadly force against Anthony Huber, correct?
Yes.
You intentionally used deadly force against Gage Grosskreutz, correct?
Yes.
With regard to Joseph Rosenbaum, you fired 4 shots at him, correct?
Yes.
You intended to kill him, correct?
I didn't intend to kill him. I intended to stop the person who was attacking me and trying to steal my gun.
Since August 25th, 2020, this is the first time that you have told your story.
Sustained.
Since August 25th, 2020, you've had the benefit of watching countless videos of your actions that night, correct?
I've seen certain videos, not all of them. I've seen a majority of them actually here during the trial.
You've also had the opportunity to read articles. People have written interviews, things like that, about what happened that night, correct?
I do my best to avoid what people write on the internet. A majority of it's not true.
You have also sat here through 8 days of trial, correct?
Yes.
And you've had the opportunity to watch all of the videos that have been played in this trial?
Yes.
Sir, if you could please let me finish my question before answering. And I will do my best to let you finish your answer before I go on to the next question. Fair?
Yes.
You have also had the opportunity to listen to the testimony of all 30-some witnesses that have testified in this trial so far, correct?
Yes.
And after all of that, now you are telling us your side of the story, correct?
Correct.
The moment the prosecution suggested that this was Kyle Rittenhouse's first time telling his story, the courtroom hit a hard stop. Judge Schroeder immediately sent the jury out. That decision wasn't dramatic. It was procedural, and it was necessary. When a line of questioning risks crossing from legitimate cross-examination into something legally improper, judges remove the jury to prevent damage that can't be undone. Jurors don't get to on hair a suggestion once it's planted. And this one mattered. By emphasizing that Rittenhouse had never previously told his version of events, the prosecution was skating dangerously close to penalizing the defendant for exercising his constitutional rights. Specifically, the right to remain silent and the right to testify only at trial. That's not a credibility issue. That's a constitutional boundary. With the jury gone, Judge Schroeder addressed the problem directly. The concern wasn't about tone or pacing. It was about fairness. Suggesting that a defendant's story is suspicious because it wasn't previously shared invites the jury to draw an inference the law does not allow. This is exactly why juries are excused in moments like this. It allows judges to enforce the rules without prejudice, and it reminds both sides that advocacy still has limits. In this trial, that pause became another reminder. Winning a case doesn't mean pushing every angle. It means staying inside the lines the Constitution draws.
He's commenting on my client's right to remain silent.
No, Your Honor. I am making the point that after hearing everything in the case, now he's tailoring his story to what has already been introduced.
The problem is, this is a grave constitutional violation for you to talk about the defendant's silence. And that is, and you're right. You're right on the borderline, and you may be over, but it better stop.
Understood.
This is, I can't think of the case, the initial case on it, but it's this is not permitted. All right. Yes, the jury.
Judge Schroeder draws a firm line the moment the prosecution drifts toward Kyle Rittenhouse's post-arrest silence. He orders Mr. Binger to stop immediately. This isn't a technical warning. It's a constitutional one. As a matter of settled law, prosecutors are barred from using a defendant's decision to remain silent as a weapon against them. Once a person is advised of their Miranda rights, that silence cannot be spun into evidence of guilt or dishonesty. The Supreme Court made that clear nearly 50 years ago in Doyle v. Ohio. You cannot tell someone they have the right to remain silent, and then punish them for exercising it. Doing so violates due process at its core. Mr. Binger attempted to frame the issue differently. He suggested that Rittenhouse had tailored his testimony, that his account was shaped by media coverage and what he'd heard in the courtroom. But that argument runs straight into the same constitutional wall. When the implication rests on prior silence, it becomes impermissible, no matter how it's dressed up. Judge Schroeder recognized the danger and shut it down. After the jury returned, the cross-examination continued for about 20 more minutes. But instead of recalibrating, the prosecution walked into another problem. Mr. Binger pivoted to the very video Judge Schroeder had already ruled inadmissible. The clip recorded weeks before the shootings where Rittenhouse made comments about suspected shoplifters. That move wasn't subtle. Raising excluded evidence in front of a jury isn't aggressive lawyering. It's a gamble that risks ministerial-level consequences. At that point, the issue was no longer just about strategy. It was about respecting the court's rulings. And in this trial, those moments added up. They revealed the tension between pushing a narrative and staying within constitutional limits. A balance every prosecutor is required to maintain, especially when a defendant's liberty is on the line.
Leave the state of Wisconsin, is that right?
Other than the night after, other than that.
Before the shootings.
Correct.
There was a time, though, where you wanted to have it with you down in Illinois, isn't it? It wasn't there?
I believe there was a time when me and Dominic were mad at each other. Yeah.
You were mad at Dominic?
Me and Dominic were mad over something.
And you wanted to have the gun with you down there?
I think I said something along those lines.
You'd agree with me that, let me back up for a second here. You have testified to this jury that you used deadly force against Joseph Rosenbaum, Anthony Huber, the man who attempted to kick you in the face, and Gage Grosskreutz on the night of August 25th, correct?
Yes.
And you did that because you felt that your life was in danger from those four people, correct?
Yes.
And you are telling this jury that it was, in your mind, justified to use deadly force to protect your own life, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
Well, I wasn't using deadly force to protect the property. I used deadly force to protect myself, so.
Please listen to my question and answer my question if you can. You'd agree with me that you were not allowed to use deadly force to protect that CarSource building, correct?
Yes.
You'd agree with me that you were not allowed to use deadly force to stop someone from smashing the windows of an unoccupied parked car, correct?
I don't think you could use deadly force for that.
You'd agree with me that you can't use deadly force to stop someone from lighting a metal dumpster on fire, correct?
Correct.
You'd agree you can't use deadly force to stop someone from lighting a flatbed trailer on fire, correct?
Correct.
You'd agree with me that you can't use deadly force to stop someone who is about to start an unoccupied car on fire, correct?
Correct.
you'd agree with me that you can't use deadly force to stop someone from lighting some traffic cones in the middle of the street on fire, correct?
Correct.
So you understand that there's a difference between using deadly force to protect yourself and using it to protect property, correct?
Yes.
And you'd agree with me that you're not allowed to use deadly force to protect property, correct?
Yes.
But yet you have previously indicated that you wished you had your AR-15 to protect someone's property, correct?
I'm going to ask you to go into the library again for a moment, please.
When the prosecution circled back to the excluded video, Judge Schroeder stopped the proceedings again and cleared the courtroom. That alone tells you how serious the issue had become. This wasn't confusion. The court had already ruled. The video had been addressed, analyzed, and excluded before trial ever began. So to understand why Judge Schroeder reacted so sharply, you have to understand what that clip actually represented in legal terms. The problem wasn't relevance. It was purpose. The video wasn't being offered to explain what happened in Kenosha. It wasn't tied to the specific encounters that led to the shootings. Instead, it invited the jury to draw a much broader and far more dangerous conclusion, that because of something Rittenhouse said weeks earlier, he was the kind of person who would commit violence. That's exactly what the law forbids. Wisconsin law sharply limits what's known as other acts evidence. You can't introduce a defendant's prior behavior simply to suggest bad character or a violent disposition. The rules allow exceptions: motive, intent, preparation, absence of mistake. But those exceptions require a direct and legitimate connection to the charged conduct. Judge Schroeder found that connection was missing here. The video didn't clarify intent at the moment of the shootings. It didn't explain decision-making under pressure. It didn't establish preparation tied to the events in Kenosha. Its only real effect was to poison the well, to encourage the jury to reason backward from character instead of forward from evidence. That's why it stayed out. So when the prosecution raised it again during cross-examination, the issue wasn't just evidentiary. It was structural, allowing excluded propensity evidence to seep into questioning risks, undermining the fairness of the entire trial. With the jury excused, Judge Schroeder addressed the matter directly, reinforcing a principle that sits at the heart of criminal law. Defendants are tried for what they did in the charged incident, not for who the prosecution wants them to appear to be.
And he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an
Mr. Finger?
First of all, Your Honor, this was the subject of a motion. I'm well aware of that, and the court left the door open.
For me, not for you.
My understanding of
You should have come and asked for reconsideration. You did on the one motion, and in fact, I granted your motion for reconsideration.
That was not our motion.
Excuse me. I did. I granted.
We did not move
That
to
was
reconsider.
their motion.
We have not filed
forgive
any
me.
motions to reconsider
Forgive
in
me.
this case.
That was their motion for reconsideration, which I denied. But I said I denied it, or I indicated a bias towards denial is what I did. Held it open with a bias towards denial. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that. So I don't know what you're up to.
May I respond?
Yes.
We filed an other acts motion on this exact issue because, in my mind, and I argued this, it is identical to what was going on the night of August 25th, in the sense that the defendant was using this exact same weapon. He was using it in a manner to try and protect property.
No, he wasn't.
Your Honor, with all due respect...
I'm not going to rehash the motion. That's absolutely untrue. No. Your arguments of record My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed, even if you're correct in your assumption that you know more than I did at the time. You should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
Your Honor, there have been things in this case, testimony in this case, that I believe opens the door to this. For example, the defense has introduced evidence that the defendant pointed a gun at a man wearing yellow pants because that person was on a car on the car source lot. Now, there's no justification that I can think of why the defendant would point that gun at someone. The defendant has just testified this morning that he agreed with that person in the yellow pants, that he pointed the gun at him. He said, I was joking when I said that to the guy in the yellow pants, but he said, he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car.
He said, I did. That's what he
Exactly.
testified.
So he's agreeing. May I finish, please? I'd like to have a chance to make a record if I could, without being interrupted, if that's okay. He has mentioned that he's acknowledged that he's used this gun to protect property. He's also just acknowledged that he knows he can't do that. I am attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property. It goes...
He had the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting, Your Honor, because the entire defense theory in this case is Joseph Rosenbaum, who was unarmed.
I want you to tell me what the defense theory of the case is. I want...
May I respond to what you just said, Your Honor? I'd like to respond to what you just said.
Slow down, please.
I apologize, Madam Court Reporter, but I'd like to try and make a record without anyone interrupting me, if that's okay. I believe that there is a central part of this case that Mr. Rosenbaum is making threats that he has no ability to carry out. So, to your point, Your Honor, you're arguing that this August 10th incident, one aspect of why you don't believe it's relevant is the defendant didn't have the gun with him. This case is about someone who didn't have a weapon, and yet the jury is being told because of those threats, that means the defendant has to defend himself. So, with all due respect, Your Honor, mere verbal threats have already been shown to this jury and used as a basis for someone's subsequent actions. I am attempting with the defendant to use his mere verbal threat on August 10th, 15 days prior, that he's going to shoot shoplifters with his AR-15 to impeach the defendant in a murder trial. I would ask the court's forbearance to do that. I apologize, Your Honor. You're right. I probably should have brought this to your attention earlier. I may have misunderstood your ruling. I believe, based on the evidence that we've heard, and more specifically, exactly what the defendant said earlier about admitting pointing a gun at someone who was merely jumping or sitting on a car, that the door is open now to this testimony. And I continue to believe that his state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion. You were strongly inclined against it. I understand that. But now we're in the middle of trial, and there's been a lot of evidence that's come in that I think makes this relevant. So I'm attempting to impeach the defendant on his beliefs. I believe I'm entitled to impeach the defendant on his beliefs and on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call...
His statements too, Your Honor. Because he just said, can't use deadly force, can't threaten to use deadly force to protect property. So now I'm impeaching him on that.
Your Honor, the court has seen no reason to change its ruling. And just so this record is clear, in spite of the lengthy statement by Mr. Binger, before we started today, the court specifically stated in Mr. Binger's presence, there's been nothing to have me change any of my rulings. There have been numerous occasions during this trial where they've opened the door. The one time when they're going into Mr. Rosenbaum's prior, the reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop, and he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. That is exactly what 90404 is designed to prevent. You're talking about his attitudes. His attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the
Don't
defense testimony.
get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the whole rule. Those are all the exceptions to 90404. Check the authorities. Wigmore and evidence. Judge Weinstein. Colonel McCormick. It's the prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense. That's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, and when you were I said you were over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule.
Once the jury returned to the courtroom, the trial moved forward, but the direction of the case had already been shaped by the court's intervention. From that point on, the focus was no longer just on the facts of the night in Kenosha, but on whether the prosecution had respected the legal boundaries required in a criminal trial. Before the case was ever submitted to the jury, Judge Schroeder removed one charge entirely. He dismissed the misdemeanor count alleging possession of a dangerous weapon by a minor, concluding that the statute simply did not apply to the type of rifle involved. It was a narrow, technical ruling, but an important one. Criminal statutes are not flexible instruments. If the facts don't fit the law, the charge cannot stand, no matter how politically charged the case may be. That ruling alone underscored the court's role as a gatekeeper, separating public outrage from legal sufficiency. The remaining charges were left for the jury, who deliberated for approximately 3.5 days before returning not guilty verdicts on all counts on November 19th, 2021. Those verdicts reflected not only the jury's assessment of the evidence, but also the limits placed on what the prosecution was allowed to argue. And those limits mattered. Throughout cross-examination, the prosecution repeatedly tested areas that the law treats as off-limits. First, by implying that the defendant's post-arrest silence should be viewed as suspicious, despite decades of Supreme Court precedent making clear that silence after Miranda warnings cannot be used against a defendant. Then, by attempting to revive a video that had already been ruled inadmissible before trial even began. When challenged, the justification offered was that the defendant had opened the door. But Judge Schroeder made a critical clarification. Even if a party believes testimony has changed the evidentiary landscape, the rules do not allow counsel to simply charge ahead. The proper procedure is to approach the court, argue for reconsideration, and obtain a ruling before exposing the jury to potentially prejudicial material. Skipping that step isn't aggressive advocacy. It's a breakdown in process. Prosecutors are held to a higher standard because the consequences of overreach are severe. When constitutional protections are disregarded, it doesn't just risk reversal or mistrial. It undermines confidence in the entire proceeding and shifts the focus away from lawful proof toward insinuation. This phase of the trial highlights why disciplined advocacy matters. Respect for evidentiary rulings isn't optional. Constitutional boundaries are not strategic obstacles to be maneuvered around. They are the framework that ensures verdicts are based on facts tested by law, not emotion or speculation in the end. This case stands as a reminder that the justice system works best when all parties, especially those wielding the power of the state, stay within the lines drawn to protect fairness. If there's a case or courtroom moment you'd like us to analyze next, let us know in the comments below. Thank you for watching, and don't forget to like and subscribe so we can continue fostering a more informed society.